Yeah, sure.
Alright, so for the good guy guarantee or personal guarantees, does that typically end up being the owner himself? Or is it just as often that it's an outside person, or if there's two owners, is it one sometimes or not both of them?
Right. So the question is who is typically the personal guarantor or the good guy guarantor? And yes, typically is an owner of the business or somebody connected with the business. It doesn't necessarily have to be from the landlord's perspective. It should just be somebody who's creditworthy and is agreeing to take on the obligations of the tenant in a personal capacity. The landlord shouldn't really have strong opinions about who it is.
I'm thinking more about the counseling piece. So then are you making clear that you're the lawyer for the business owner, and not the person? How much explaining are you doing of what that causes to the person who's the personal guarantor, and then, like, you would counsel them one way if you were their attorney. It's different than what the business owner's interest is, and just how does that come up?
Yeah, that's an interesting question. I guess it kind of goes to some ethical considerations about who exactly is your client. I haven't run across the experience where we've actually advised the personal guarantor to obtain their own counsel. I think that we're capable of explaining what the considerations are and what the risks are, while always explaining to always explaining to the client, the personal guarantor, who the client is. My client is the tenant. My client is the LLC or the corporation that's signing the lease. But that doesn't necessarily bar you from explaining the terms of the good guy guarantee effectively to the guarantor. Yeah, it is a little bit gray.
I've seen in similar circumstances where you have that, especially in this kind of pro bono atmosphere where you're trying to just make sure it's a good deal for the client, but there's other related parties involved. Just having a simple no attorney acknowledgement signed by the person that's involved, and it just says you understand that I don't represent you, I represent the other person.
And there is a provision in I think it's not in the retainer, it's in the application. There's an extra page for multiple owners. I don't remember the exact language there, but it kind of speaks to a few of these issues that are, reminding all involved that who our client is and where our ethical obligations flow. So maybe covered there. Any other questions?
Sure. So with respect to the waiver of redemption, that's why we talked about that commercial landlord has no duty to mitigate, so if they want to, they can sit back and collect rent. Now, in the event that landlord gets another tenant in, what, in your experience, has been the case law? I mean, can they sit there and actually get rent under the new lease and then also keep collecting rent under the old lease?
Yeah, so they can collect the differential. So if I was supposed to pay you $1,000 and I'm out, and the next tenant that you get only pays $500 for the same lease term, you still have damages accruing at $500 a month as against me.
Okay.
And you could potentially, at the end of that lease term, sue me in Supreme Court or whatever court of competent jurisdiction for all of those damages that you've incurred under the lease.
But you have to sue as the old tenant who's no longer in possession of the premises. You basically have to identify that issue in case there's an unscrupulous landlord that's collecting both.
Right.
Basically,
and that would come out.
The tenant has to go to court.
That's one of your only defenses, is that you're not entitled to the entire amount. You started collecting some rent, and so you're entitled to the deficiency. But yes.
What about if there's an accelerated ratification and for some reason the business actually has the money to pay it? So they pay almost okay, here's the rest of my 5 years, and then they break, and then the landlord breaks in someone 6 months later, and they're paying the same amount of rent for this scenario. What happens to the original tenant? Do they cut their out of luck?
Yeah, in that case, it's two separate provisions. The accelerated rent is a penalty. And yeah, even if the landlord chose not to go the accelerated rent route, or if the tenant wasn't able to pay, then the other provision, this remedies non-waiver provision, would kick in, and the landlord would be able to sit there and collect rent that way.
Arthur, can you confirm my understanding that in a non-payment summary proceeding, even if the notice period to pay has passed, once the proceeding is started, if the tenant makes a payment at any point, the landlord is actually obligated by law to accept it, and the case will be dismissed?
That's correct. That's correct. There may be some dispute about what exactly is outstanding, whether any certain costs of the non-payment proceeding, whether some attorney's fees are due, which of course are rolled into additional rent. So, in the hypothetical instance where the tenant completely clears all of its obligations, all of its monetary obligations, the non-payment proceeding is moot. There's no more debt under the lease.
I know we don't, we're not going to be advising on that, but I can see the question. A lot of clients are like, well, what happens if I get sued? And
Right.
It's kind of common
Right.
concern.
Right. Conversely, if there's a holdover proceeding and the landlord is trying to terminate the lease or has terminated the lease based upon non-monetary default, and then continues to collect rent, then that has been found by courts to be a revival of the lease.
So they dismiss.
So they'll dismiss for lack of jurisdiction. Yeah. So rewinding back, so let's say that the tenant has a non-monetary default and the landlord serves a notice to cure. The tenant doesn't cure but pays its rent. The landlord accepts the rent but then goes forward with a holdover proceeding based upon supposedly terminating the lease for the non-monetary default. I, as a tenant, can come in and say, hey, but they accepted my rent. They revived my lease. So this holdover proceeding, it must be dismissed.
So revival, not holdover. So
right.
awesome.
Well, the chain's determination. So
Yeah.
again, it's like reinstated tenancy. But then when that happens, are they now considered, like they have to issue notice, but are they considered, does it reinstate the terms of the original lease, or is it a month's
holdover. Exactly, that's what I was thinking.
Depends upon which stage at which the rent was accepted. If it was accepted before the termination, it revives the lease as it was. I have to look at the case law to see what happens after termination.
And what about the cure? What if they cure after the notice of termination? What if they cure the breach?
If they cure the breach after the notice of termination, the tenant can ask the L&T court to reinstate the lease as part of its order, or have the lease reinstated or deemed continued as part of its order.
That wouldn't be a slam dunk, right?
No.
I mean,
No, and that's where we'll talk about Yellowstone proceedings. Next week, there's a very small window of opportunity for the tenant to rush into Supreme Court and get an injunction staying the tolling of the notice to cure, giving them a little bit more breathing room to actually cure the default before the lease is terminated. Maggie?
With the fees and expenses, so we're trying to draft it so that, it's no matter, like, whoever the prevailing party is, they have the right to the attorney's fee. So, like, as it's drafted now, it's like if the tenant is in default, or are we reframing the whole Power Act to be like, if either party, is that in violation of the lease, or is it more specific?
You can do it that way, but a tenant who's hauled into L&T court and successfully defends against that is also a prevailing party. So if the landlord brings an action that ends up being dismissed based upon the tenant's defenses or motion practice or whatever, or even after trial, the tenant should be deemed the prevailing party, even though it didn't bring its own action based upon the landlord's breach.
Yeah.
So it should be written in a way so that the prevailing party can either be the plaintiff or the defendant in whatever proceeding we're talking about.
I have a question about real estate taxes. So a couple years ago, we had a client who was in a long-term lease, about a 20-year lease, I think, and 15 years of not charging for real estate taxes, the landlord sent her a real estate tax bill of like $8,000. Like, oh, by the way, you owe this. Now, I know that there's definitely some ways to kind of avoid that situation happening while writing a lease, but this was a lease that was written 20 years ago. So, you know, I'm sure there's statute of limitations on debt, but I don't think that they have even that time would be started because it would have been because the lease is continued up until this period. So I think that they can collect throughout the period of the lease. But and in this instance, we were able to get pro bono counsel. As soon as we got pro bono counsel involved, the landlord backed off, probably realizing that that was crazy and that they needed to be on top of their bills a little bit better. But I mean, they would still. I don't see any reason why, based on the template or the form lease, that the landlord couldn't collect those taxes 15 years later. Is that?
Not based on the form lease. I think they have a statute of limitations problem. To the extent that any of them were accrued and were due more than 6 years.
But even if it's within the same lease period, that's what I was getting on.
What do you mean in the same lease? Like in the same lease term?
Same lease term. Would the 6 years have started? It would be 6 years after the term of the lease ended.
Well, it depends upon how they have to bill it. If they bill it every year, once a year, or every 6 months, all of the ones that were billed or were supposed to be billed more than 6 years for should have been severed off as right as statute of limitations restricted. Even aside from that, I would make an argument that they waived their right to collect these fees. There is I think we talked about it. We may have talked about it, but there's a very broad no waiver provision, but there's a body of case law specifically for commercial landlords that says that they can waive no waiver provisions. And I think 15 years of, by overt or non-overt actions. And so 15 years of not collecting this fee that's supposed to be due under the contract, I think would rise to the level of waiving the no waiver provision.
We could also put that in, right, that they have to, like, in order to collect additional rent, you have to timely or promptly or whatever, like, kind of put a stopgap, right? You probably have to bill the tenant, within a yearly basis or whatever, and if not, right, they say, well, I want to say, well, that's not fair, like, how can they budget and plan to be able to pay for something when you're not going to know what's occurring?
I think that a provision like that would be helpful, even stopping short of saying that failure to comply with this would be waiver, even just saying that the landlord is obligated to provide timely notice of any fees or expenses that are due would go a long way into making a waiver of the no waiver provision argument later on.
And we talked about this, Arthur, that like, at least in the residential context, they recognize latches as an equitable remedy, and we said, in this case, commercial,
It is dear commercial latches.
Well, yeah, but I mean, in cases where it's something like taxes, I think that's an argument because essentially you're depriving the tenant of an opportunity to pay by waiting 15 years and then billing all at once. So essentially, trying to get them out of some fees and jamming taxes.
Yeah. And then so you had mentioned too that we should be asking for, asking for the ability for the tenant to contest the real estate tax assessment, which, as I think in the form lease, you don't have the right to contest the assessment. And I had another client in which they would get their real estate tax bill in the summer, but the assessments are usually done in March, and it would be too late. So if we are going to include a provision where the tenant can contest, the landlord needs to give the real estate tax bill. I mean, they could get it publicly, I guess, I'm not sure how fast they get posted, but the tenant needs to get the bill in like a short time span in which they are able to contest.
Well, they're posted pretty timely, and they're public record. And also, as you saw in the example that I showed, there's normally an estimated assessment for the following billing term. And so you can see what it's going to be. It'll be confirmed, when that actual bill comes out, but it's usually pretty close unless there's some kind of abatement that goes into effect or some kind of credit or additional interest. So I think that might be enough to go on for the
Right,
tenant.
or and advise the client that they need to, like, diary, that they need to grab the tax bill when it comes out in March, and they put, and not wait for the landlord to send it out.
Right.
I had a question about the tax abatement. So if there is an abatement, how do you find out like how long the abatement would last? And is it reasonable to ask that like a tenant continues to pay taxes as if the abatement wasn't in place, if it goes away in the future? Just what do you advise?
You could see the abatement information. I should have pulled one that had one. Maybe I'll bring that for next week, and you can actually see it right there on the tax bill. There's a line. There's going to be line items there for any effective abatements, and they should be on for the estimated one for the current bill, for the current term, and for the estimated following term as well. There should be any kind of estimated tax abatements or adjustments there. It wouldn't be fair for the tenant to pay the unabated amount. To the extent that there is an abatement, the landlord is enjoying that abatement, and that should be passed upon to the tenant as well. I think another important consideration is that if the abatement is going to run out during the course of the lease term, then the tenant's obligation of real estate taxes may jump at some point pretty significantly.
Yeah, that's what I was thinking.
And so, yeah.
So in that instance, that you just advise them amend their taxes.
Advise them that in year whatever the taxes may jump to, whatever you estimate it to be because of this abatement that's set to run out, and see whether that's feasible.
So I know this is exemption, yes, no, right? But then it actually will say when it's set to if either just like step down or stop.
I think it's on the bill,
Yeah.
but it's,
Yeah.
I think there's another, like, site or link you can go to, and I think it should say the time period. For certain ones, it'll say like 15 years, other ones will just say this tax year, but I'll see if I can find that one.
There may be a filing on ACRIS as well that can tell you.
If it's like recorded, property exemption.
I know there's summary pages that'll tell you the terms of, especially for the more popular ones, like Dickerson or something like that, but I think on the actual DOF website, it just tells the type, if you're not familiar with that type of exemption. For example, if it's a partial or full or evaporating over time, you have to be familiar with the technical tax exemption itself. But there are summary pages that I think do a good enough job to kind of get you there for probably our purposes, except for the partials and those kinds of evaporating or partials, we don't, you would have to more intimately know the exemption.
Yeah. There's scree adjustments I know that show up on the bills for like if you're in a building with senior citizen residents, then they may get a break on their tax bill, and that'll actually show up, and that should be passed along as well, based on proportionate share.
In the standard form lease, where does it address what would happen if the landlord sells the building? Is that one of the successors in assigned? Which one who's buying it be a successor?
If the landlord sells the building?
Yeah.
So that's addressed at least in paragraph 7 in subordination. That the lease you're signing is subordinate to ground leases and underlying leases to mortgages.
That currently that could exist in the future.
It's my understanding that as an operation of law that an effective lease will continue even if the ownership of the fee changes, right? The lease term is going to continue. You just have a different landlord step in the shoes. I'm going to think about that and see if there's a separate provision that we typically see in riders.
I know they, because I think I had asked you about this for lease we were doing this, and there was a provision that spoke to the mortgage included. I guess this is a little different than the successor assigned, but for example, if a mortgagor forecloses on a property and wants to change or modify the terms of the lease, the tenant's required to kind of sign or offer some of those modifications.
Right.
That's the other thing.
Right. Yeah. As far as changes of ownership on the landlord side, In the instances that I've seen, it's just been kind of a seamless handover of the lease, and the buyer, the buyer should be aware that there is a tenant in there based upon a written lease, and they take subject to that tenancy.
Yeah, I don't know, if we're just talking about a normal, like, acquisition, transfer, or merger, you can't just, unilaterally, break the lease because we're the new owner.
Right.
And unless the lease has a term or something.
That's what I was worried, buried in here somewhere, but it sounds like no.
Unless the new lease has a term?
Unless there's some strange term in there that says that if the new successor or transfer decides to change the terms of the lease, they can.
Right.
Unilaterally.
Right. That would make my ears perk up. I don't know that there's anything like that in the form lease. If there was anything in the rider, I would definitely push back on that. And but do be aware that to the extent there is a new owner, they're required only to comply for the existing lease term. They may not be obligated to provide any extension options. It's going to be at their discretion.
I do remember trying to mark up that provision though, because there was something that I was uncomfortable with about it, at least the ambiguity, and just not wanting anybody to touch it. That's really common. They just don't want any limitations on transfer rights. So I remember trying to clarify that, because I thought it was just purely poorly drafted and was open to some interpretation, and I can't remember exactly why, but just remember reaching out to others.
There's some funky things that happens if you're the subtenant, and the over landlord takes possession or holds the sub landlord, your direct landlord, in default, and then either terminates the over lease or takes repossession of the premises. There are some tricky, funky things that happen in that instance. In some instances, the subtenant becomes a direct tenant of the landlord. In other instances, the subtenant may be subject to eviction. That's something that's always been a little bit tricky for me, so I may look into that as well and kind of report back next time.
This is not so much related to the lease, but we have our first client we're meeting with them on Thursday. She runs what sounds like just a place where she'll host parties for kids, so we're gonna just double check that it doesn't constitute licensing as a daycare. Then the general question of what all does are there other things that the building needs to comply with, and how do we figure that out? I'm thinking of the city's page to plug in what type of business you have, not just put down what type of permits or licenses you need. How else could you try to figure out what the scope of things she needs to have? Make sure the building has these things.
I'm not familiar with that website.
It's called Step by Step. Well, they call it Step by Step. You should call it Business User
Solution.
It's on the business. It's on the Small Business Services website, and if you go to start a new business, and then it'll have something that's step by step, and you click on that, and you put in all the different things your business will be doing, and it spits out all the different licenses and registration, and all the different agencies that might be overseeing what you're doing.
Including building specific stuff.
But it doesn't go into buildings, it doesn't go into code like that, like if you're doing a daycare, it's not like you have to have this many toilets and sinks and things like that, so I don't think you need to have an architect or someone who knows the code. But I don't think that they can expect necessarily us to be able to do that.
You could check the zoning to make sure it's not very commercial, but that's the extent of what
No, there's really
we could do.
Oh.
Just so you know, with respect to daycare, so the Department of Buildings has a specific handout for daycares.
Yeah, that stuff is all pretty complicated, but there's stuff, guidance and things like that. But if it wasn't a daycare, we were just concerned about something else we need to know about.
I mean, and the ADA compliance is really tough. Like, I don't think we're going to be able to help people through that. Like, they need to have a consultant that can help them identify.
In every space needs to be compliant.
It's open to the public.
There's a new help service. There's a new help service for the city's offering for ADA compliance within the past month or two. Have you heard about this? The mayor's office to provide you with resources for ADA compliance. Hopefully that won't fall on our client's responsibilities list. But to the extent it does, it seems like there's some enhanced resources out there from the city.
Yeah, and it's unfortunately too. I mean, I worked with someone who had an architect come in and said, "Oh, this is ADA compliant, just want to the bathroom because the bathroom's not, but it's going to cost them a ton of money to do it." And then they got hit with a lawsuit like 6 months after they opened, so it's a tiny little restaurant. And so we were actually with them for a little council, but that's very rare. But yeah. Even having an architect
was for not being ADA compliant.
Yeah. We're starting to see a lot more of those types of suits in New York. They used to be there. Have been prevalent in California.
I didn't hear the landlord's not saying that the son of a landlord is ADA compliant, right, in the standard form?
I think it's vague. It needs to be expanded in the rider, because in the form lease it says that the tenant shall comply with all laws, rules, and regulations, and that could be read to include ADA compliance.
So the tenant has to bring it up to ADA compliance.
But you could try it.
So you could try to negotiate if you don't want to call out ADA specifically and call the landlord's attention to it, you could try to say that it notwithstanding anything in the form lease, it's still the landlord's obligation to conduct any repairs in order to get the property in compliance, to do any capital improvements to get the property in compliance.
Some of the ADA requirements are not even like they're not even just structural, right? It's like to hide your tables.
Yeah.
Like the landlord's not going to have the ability to verify that or bring it to the attention of the tenant. And I mean, besides architects, like there are probably companies out there that will do like an ADA compliance check and sit down and do a consultation with you. It might be something we should consider looking into and adding to the list of additional resources along with brokers.
That was what I was gonna say. I didn't realize we had that list. I was gonna say maybe a good idea to have a running list of all these things we talked about. So if someone who measures the square footage, if someone wants to be more precise about those kinds of things, and kind of estimates of costs. Because you don't want to tell a client, oh, I mean, we need X, Y, Z consultant, and they're like, how much is it gonna cost me? It'd be nice to like give them some kind of range of, I can't promise, but you may be looking at an additional $1,000, $5,000. Because that may help them determine whether or not they want to enter into this lease.
And like what Angela was talking about, just a list of like resources on for childcare centers and stuff that we can just forward on to them.
Yeah, I think it might be useful to keep an ongoing list of like, here's all the considerations we made for a salon, for a daycare, for a restaurant.
We talked about ADA compliance and like maybe is that the DOE code that we're talking about in terms of like how
They're federal guidelines.
Well, not with ADA. I mean like just the other kinds of like requirements that you have this many egresses or like this many toilets or this. Like is this DOE stuff? Yeah.
It is online.
Yeah, right.
Yeah, it's just way too dense.
Yeah.
I think it's available, but it is dense.
Yeah.
Like an attorney could, it's just so technical. It's like, you, as an attorney, when trying to do that, you really need an expediter, someone who has technical proficiency as an engineer or whatever.
But I think it's all in the administrative code online.
Yeah, so the city is really trying to address some of that internally with their own programs, like, I guess maybe they are doing an ADA one. So you could talk to SBS and maybe even next week, because they are trying to make it a simpler process for people to get direct access to the department buildings to figure out what they need.
I guess the problem is no one wants the liability, because at least with an architect or an engineer, you have professional liability, you can sue for malpractice. But if it's not a licensed professional that's giving you a professional opinion.
Do you think SBS would help in terms of DOE? No. Do you think they're like?
Yeah, they're trying to, well, yes, they created this program where they were having representatives of each each of the agencies that like regulate a small business be available for consultation. And I can't remember the name of the program, but they started it about a year ago. So they should know a little bit more about natural resources than we do. And I don't know where they send people to specific, I'm sure they don't recommend individuals, but I'm not sure what they do.
We started creating this list of resources.
We have that for list of places to refer people if we can't pick them on.
But not a checklist of places for you to look, like check this, what, these 10 websites, like how to do their own diligence, people they should talk to.
Well, so the lease guide does have it in general terms, right? Like you should contact an architect, here's an idea, like, do due diligence when you pick an architect, here's the contract they'll do for you. They had expediter language in there, and the city actually struck that language, so I'm not really sure. They like I tried to use different language that wasn't the term expediter. So I guess there's
sensitive that
yeah, like
actually need
right. That's probably the one. So there is language in that commercial lease guide about that, but it doesn't have specific recommendations that we could start developing those. So we could just, if you wanted to start by circulating, we do have court accountants and brokers, and then we can start adding to
Architects, engineers, expediters.
And attorneys for litigation.
We almost need a critical mass in order to actually use it. So we also like recommend or something.
Yeah. But we do like elevator inspections, those kind of heavy front end costs that people want to make sure they don't have to pay for. Because we have a client who's, I mean, luckily they have someone, but it can be tough if you don't know what the cost is.
I mean, elevator would be a common element. That's the responsibility of the landlord. I would have an obligation. Well, I would have a representation.
This he specifically was like, you can use this building without it. It's not a big tall building. You can use the stairs.
So he wouldn't even represent that it was compliant.
He told her it's not working. So he didn't. He disclosed like it's not in use, and if you want to fix it, you need to pay money. Yeah.
And it was serving only. Well, it wasn't serving only her. Only her.
It was
Never mind.
Oh, we got free consent to install a chairlift, which is like a cheaper option that would keep it ADA compliant.
I mean, we have the 60-day language that we kind of put in there, requiring him, the 60 days when you figure out something is wrong, you have to fix it. We're trying to make an argument for that's going to be within it, but technically, their mutual understanding was that he said no dice.
It's on her. Anything else?
Thank you.
Thank you guys.